Yay, oh yay, oh yay. The Honorable Court of Appeals for the Fourth Court of Appeals, District of Texas, is now open pursuant to call.
You may be seated. Good afternoon. I will be presiding this afternoon, and I would like to introduce my colleagues. To my right is Justice Lori Brissett, and to my left is Justice Adrian Spears, and we welcome you to the Fourth Court. I'd like to call the case at this time. This is 04-2395 Saturn Aviation LLC versus BMH Air LLC and Evolution Jets LLC. I will take announcements at this time. And with me is Garrett Quick with Slot Davis Center.
Chad Group for Applee, and with me is Drew Coates.
Thank you. You may be seated. Will there be any splitting of time, Ms. Baker? All right, you may proceed.
May it please the court. It is a cardinal rule of contract construction that courts may not rewrite parties' contracts. But here, BMH and Evolution led the trial court to do just that, altered their contracts and Saturn's. The court's three questions get to the heart of the matter, so I will address those briefly first and then in more detail. First, regarding the relationship among the agreements, BMH led the trial court through all sorts of machinations to find that the original sublease and the new sublease are essentially one and the same. But those two subleases with different parties, different signing dates, different terms, and a merger clause in the new sublease simply did not and cannot coexist. BMH conflates the original and the new sublease because its only tie to Saturn is through the subordination agreement, which is tied only to the original sublease. When that original sublease terminated and was later replaced, the subordination agreement died along with it. And BMH simply has no remedy against Saturn for the damages awarded. If BMH had a remedy against Saturn solely through the new sublease, they would say so, but they don't because they can't. Second, even if the subordination agreement were operable and applied to the new sublease between Evolution and Saturn, Evolution, not Saturn, is liable for the damages awarded by the trial court under the plain terms of the subordination agreement. Third, Evolution failed to prove its damages. There is no evidence to support the monetary damages awarded, and the trial court properly declined to award lost profits, damages to Evolution, and did not award any fees, a decision Evolution has not appealed. So, for further explanation, I have prepared, and we filed and I delivered this a little while ago, some oral argument exhibits that I think will help take us through the court's questions. If you'll turn to Exhibit 1, you will see on the left-hand side, the original sublease with its effective date and key language. This agreement shall automatically and immediately terminate. At any time, MFA no longer has exclusive rights to the aircraft.
So you have MFA in brackets. Does it actually say lessor?
Yes, it does.
Okay. So if in that agreement, there was, well, obviously we have an assignment of that lease from MFA to Evolution. And within that original sublease, we have a term that says that the sublease may be amended. Why are you limiting it to MFA? Because isn't it more likely at any time the lessor no longer has exclusive rights, which would now include Evolution after the assignment?
But the original sublease defined the lessor as only MFA.
But then there was an assignment of MFA's rights and duties to Evolution. So Evolution stood in the steps of, or the shoes of MFA. Is that not right?
Well, there are a couple points on that. One is that the original sublease terminated on the day that MFA assigned its exclusive rights to the aircraft to Evolution. Okay,
So you're saying the assignment actually terminated the sublease, not the amended sublease?
right, right. Our first position, our first line position is that assignment on February 7th, 2017, that terminated the original sublease. And the subordination agreement says this agreement shall automatically terminate upon the termination or expiration of the sublease. So as we show in our chart, those terminated at the same time when under the assignment of dry lease between MFA, BMH, and Evolution, to which Saturn was not a party,
Real quick, when you
everything
say
terminated.
it terminated, so it's your position that BMH no longer has any rights at all?
Well, it has rights, but it's a two-part situation. BMH has rights under the dry lease, which it had with Evolution. And those rights, there was an assignment of the dry lease. And so BMH has rights now to Evolution through the dry lease. But the subordination agreement was its only link directly to Saturn.
Well, I was wondering how they got the plane back. I mean, and they exercised some of those types of remedies. How did they do that? If
How
there's
did?
no chain going to Saturn?
Evolution is who terminated the new sublease, not BMH.
And who got the plane back, sequestered it?
Eventually, BMH.
And how did they do that? Did they have a document that allowed that?
Let me think on that. So Evolution terminated the sublease with Saturn, and then Saturn, so that was terminated. So Saturn no longer had possession of the aircraft. BMH, in its own agreement with Evolution, could get repossession of the aircraft if either Evolution breached the dry lease or Saturn breached the sublease. So it had to follow a chain of command, basically, is what
Yeah,
I'm
and that's
saying.
what I was wondering, because I know they had to set up a bond on the writ of sequestration, and I think that was, maybe BMH can explain it to me. I just want to know how they got physical access to the plane if we have this break,
Right,
so.
right. They had rights to the plane through their contract with Evolution, and Evolution is the one who terminated its sublease with us.
So if we can go back, because I'm intrigued by this, because I'm very familiar with the idea that if you amend a sublease, the original sublease no longer applies. But you're arguing that the assignment and if MFA's rights under the sublease to someone else, when MFA remained obligated in the event that Evolution didn't perform, that renders the sublease terminated.
That's one of our arguments, because it lost exclusive rights to the aircraft. But even if you consider so the other side says, that what prolonged the original sublease and therefore the subordination agreement was a separate assignment that Saturn signed and entered into with MFA and Evolution. And so if you go to chart 2 or tab 2, that's what this shows. So there, we signed an amendment and assignment of sublease. It's effective February 7th, 2017. It wasn't actually signed until February 14th, 2017. So we say by that time, the original sublease had terminated, and so had the subordination agreement, and that's it. But even if you take into account the amendment and assignment of sublease, that at most extended for a short period of time the original sublease. It didn't revive the subordination agreement. It doesn't refer to the subordination agreement. It doesn't refer to BMH at all. And the ultimate point is that Evolution and Saturn, the party leasing the airplane to the Part 135 operator, entered into a brand new sublease.
So is it your position then that and I think you answered this to for Justice Brissett. The new sublease did not terminate the subrogation agreement. It was the assignment. Is that your position?
Well, so the first, yes, we have a couple of arguments. One
Okay.
is that the assignment, once MFA lost its rights, that original sublease was gone and the subordination agreement terminated with it. But in any event, once Evolution and Saturn entered into a new sublease, that new sublease has no link to the subordination agreement at all.
But the purpose of the sublease really was to transfer exclusive, what is it, right, I believe, to the operational control of the aircraft, right? And then for exclusive leasing, subleasing to Saturn. Am I right in that?
Are you talking about the new sublease?
Yes.
Yes. So the new sublease was a new contract between Evolution and Saturn governing the lease of the aircraft. So it had different parties from the original sublease. It was signed 11 months later, but made retroactive, and it had new terms.
And the new sublease was retroactively dated to the same date as the original sublease,
Correct.
correct? Now, the subordination agreement, that's an agreement that says BMH, you're the aircraft owner, you're going to have, your rights are superior to any lien or anything like that. So are you asking this court to, and I believe the trial court didn't agree with your position,
Right.
but that BMH suddenly going to give up its superior rights to the aircraft and everything that goes, that's included in the subordination agreement?
Well, that's a really good question. And the issue I think here is that BMH had a way to protect its rights. It had the dry lease with MFA, then Evolution. And under that, it could assert its rights in whatever it wanted to do with regard to the aircraft with respect to Evolution. But Evolution was responsible for damages to BMH.
But the subordination agreement covers a lot of things. For
Yes.
example, it requires Saturn to include BMH as a loss payee in insurance policies and things of that sort to protect its interest in the aircraft,
Mhm.
correct?
Yes.
So under your scenario, would BMH be protected in case of a loss?
Yes, and I'll get the exact language for you, but the sublease, I believe, requires the owner of the aircraft to be a loss payee on insurance.
It seems like your argument depends upon a very strict reading of the contracts where it identifies lessor as MFA and ignores the fact that in an assignment, MFA is sending all of its duties and responsibilities and rights as a lessor to Evolution. Is there any case law to say that that strict interpretation of the identity of lessor applies and the assignment terminates the original?
I don't have a case on that, Your Honor, but I will say that, under Reader, you can't, once the new sublease is there, you can't read that in conjunction, like together with the subordination agreement or the original sublease.
You're
Because
talking about the amended sublease.
I'm talking about the very first sublease, the original sublease. You can't read those together as the same transaction.
You can't read the original sublease and the subordination agreement as the original transaction?
No, I'm sorry. Once the,
That's why we're having oral argument.
yes, I figured this is a confusing one by far. No, I think my point is that you can't read the new sublease, the subordination agreement, and the original sublease as one transaction under Reader. You just can't. There are different dates, different parties, and the new sublease itself accomplished what Evolution and Saturn wanted. BMH had rights to protect itself through its dry lease with Evolution.
But could you
So-
not read the original sublease and the subordination agreement together in the sense that the subordination agreement basically says it terminates if the sublease terminates, but the sublease allows it to be amended and it was assigned to all the rights and responsibilities with MFA still on the hook if Evolution didn't apply. If you read those two together, couldn't you read the intent of the parties to be that the subordination agreement would stay in effect as long as the sublease existed in any form?
That is an argument, and our response to that is that that ended when the new sublease was entered
The
between the
amended
new parties.
sublease.
You call it the amended, I call it the new, because
Yeah.
there's also this weird middle amended thing. But yes, the new one between Evolution and Saturn. I mean, once that was entered, then there is no room for either of the others. BMH could have asked Saturn to enter into a subordination agreement relating to the new sublease, but they didn't. And so they can't fish back in time to use this subordination agreement as a hook into this brand new sublease between these parties. They could have, but they didn't.
I have a question.
Yes.
On the parties on this amendment, that's between BMH, MFA, and it says DBA Evolution. How does, I mean, isn't it the same company? or-
No, those are different companies. And it was a DBA setup, but one of the reasons that they entered the new sublease is that MFA was going defunct. I think the testimony is wound down, and Evolution Jets LLC is a different company.
So the people who own Evolution are not the same that own MFA? They're different.
I'm not going to say that, but it is an entirely different entity.
All right, I'm just
Yes.
trying to figure out the parties. Thank you.
Let me make sure I understand. So you've said that the amended assignment of the dry lease to Evolution, that ended what?
The original sublease and the subordination agreement.
Okay, but doesn't it, because that's plaintiff's exhibit 6, then why does it in section 2.2, and I'm talking about the amended assignment, say that Evolution assumes all of MFA's duties and responsibilities under the subordination agreement? Am I looking at the right document?
Which one are you on? I'm sorry.
Plaintiff's exhibit 6, is that the one you're talking about? Am I mistaken?
That's the amendment.
Is that the one? Is that the one she's talking about? Yeah. Is that the one you say ends the original lease and the subordination agreement?
Yes, because MFA lost the exclusive rights to the aircraft.
Okay, so what about the language in section 2.2 that says Evolution assumes all of MFA's duties and responsibilities under the subordination agreement?
Yes, but the point there is that Saturn was not a party to this and didn't agree to that.
So you're saying this ended the original sublease and the subordination agreement, even though the language specifically refers to the subordination agreement?
Right, because it may bind these parties, but Saturn did not sign it. And I think, that, the next point shouldn't be lost, which is in, both exhibits 1 and 2, is that once there was a new sublease, again, I mean, there's no way the original sublease and the new sublease can operate at the same time. MFA doesn't even exist anymore. It doesn't have an airplane to lease. I mean, those can't exist at the same time. And if those can't exist at the same time, and nobody says that the new sublease is void or inoperable, so if those can't exist at the same time, you have the new sublease. It has no tie to the subordination agreement at all. And that is our exhibit
You're
3.
saying they had to enter to a new sublease with Saturn?
I'm sorry,
Are you saying they had to enter into a new sublease?
new
with Saturn?
subordination agreement.
New subordination
Mhm.
agreement? But real quick, so on this amendment and assignment, you said that Saturn won the party, right? So what happens to the sublease between Evolution and Saturn, or MFA and Saturn, excuse me?
Well, there was a second, I mean, we say it ended
Mhm.
and kind of time went along, and then Saturn and Evolution entered into a new sublease that was backdated to cover the parties' arrangement.
So for a while, they were operating with no agreement.
Yes, under a second argument, Evolution and Saturn signed their own amendment and assignment of the original sublease. But that for sure ended by the time the new sublease.
It's your
was entered.
position, they should have done that with the subordination agreement as well? in
Yes.
order to do it?
Yes.
What about the trend in the Supreme Court about not using such wooden rules of construction that would absolutely abrogate the intent of the parties? I mean, if one construction actually shows that the parties maintained the subordination agreement, which everyone had agreed to, and one construction means BMH just completely loses out, which was never the intent of any of the parties, why wouldn't we take the construction that served the intent of the parties overall?
Well, I think one, because it doesn't mean BMH loses out. They had rights, but they didn't pursue them in the right way. Evolution was responsible to them under the dry lease. Saturn was responsible to Evolution under the new sublease. So there were remedies,
But they
But-
chose to pursue it under the
but they
subordination.
chose to pursue it under the subordination agreement. And I see that my time is up.
You can wrap up if you need.
Oh, so I was just going to say, and the next slide, which we'll get to hopefully, but it's in the drafts, is that even if the subordination agreement were somehow operable, Evolution's responsible for the damages, not BMH. Thank you.
I couldn't see the timer from my panicked. May it please the court. I want to talk about Reader because I think it's incredibly favorable to us, and particularly in light of Justice Brissett's discussion of the intent of the parties. But I better talk about the assignment and the amended sublease for at least a few minutes before I get there. But my focus really is going to be on Reader. So let's start with the assignment. And the important thing for everyone to remember is the original sublease permitted assignment. That's section 10.9. It said as long as Saturn consents, assign away. And that's what MFA did, and Saturn consented, right? And Saturn not only consented, but said, there's a clause actually in that assignment Saturn signed that said, we're amending in accordance with the amendment provision of the original sublease. We're assigning with consent in accordance with that provision of the original sublease. And we're agreeing the original sublease continues on in full force, signed by Saturn. Their only response to that is to point to some evidence in the record suggesting maybe that wasn't signed until a week later. Now, here's the problem. Setting aside whether that's even legally a valid point, here's the problem factually. There also is evidence in the record it was signed on February 7th. Who gets to resolve that discrepancy? The trial court. And the trial court did. If you look at the assignment Saturn signed, I'm reading right from it, right above the signature line, you will see an acknowledgement that they signed it on the day it was effective, February 7th. So Judge Abels was perfectly entitled to look at that evidence and say, you know what? I've got conflicting evidence as to when it was signed. I find the evidence more persuasive it was signed the same day. So I think that pretty much kneecaps this argument about the assignment, that assignment terminating the original sublease. So what about what we call the amended or new sublease? And I will tell you, we don't think it matters what we call it. We think we're going to get to the same place in the end. A number of problems with that argument. So their argument is that this is a different contract with different parties. The problem with that argument is it doesn't result in termination. It results in a mess. Okay? If that's true, if these are different parties, they have no ability to terminate someone else's contract. How in the world would that work? Parties C and D can't terminate a contract between parties A and D or A and B and anybody else. Now, they may be right that it created a legal nightmare. Maybe you had now two contracts. Maybe MFA was in breach. I don't know. I mean, none of that, of course, really matters. But the point here is two different parties can't terminate someone else's contract. And remember, under all of these agreements, MFA, even though they assigned over to Evolution, they retained liability under the original sublease as sort of a backstop, if you will, for BMH to recover from. So we just don't think it gets them there. But really to us, and now this does take me to Reader, I think what really happened here is that Judge Abels looked at all of this and said, this was all just one deal. This was just part of one overall transaction. And that is entirely consistent with Reader. All of the things that sort of happened or were missing in Reader didn't happen or aren't missing here. Let me give you a few examples. One of the things the Supreme Court cited in Reader was that the LLCs at issue didn't have any legal claims against each other, and that bothered them, trying to enforce those contracts in that context. Well, here they do. Everybody involved in these agreements, other than MFA, which has a successor or assignee, I should say, everybody has claims against each other. So it's not like Reader in that respect. Secondly, and this is, I think, probably the more fundamental point, is the contracts had totally different purposes. If you will remember, in Reader, you had the Cadbury agreement, which established an LLC without any limitations on its purpose. It's just engage in any lawful business. And then you had those series agreements that were very specific to selling medical devices. And the Supreme Court looked at those and said those are totally different purposes. Well, here, there's no different. All of these contracts, start to finish, 2 assignments, sublease, new/amended, all of it, subordination agreement, was to fly this airplane. Saturn's going to operate this airplane owned by BMH for the middle party MFA assignee Evolution. They all served the same purpose. There was no other purpose. Nobody else was trying to do anything else but operate this airplane. So that's the second factor, I think, that makes this very different from Reader. The third factor is that even the different parties idea is a very different context here than it was in Reader, right? I mean, in Reader, it really was different parties. Here, yeah, technically they are different legal entities, but one was a successor and more importantly had an assignment. So, okay, it's technically different parties, but is it really the same type of different parties the court was talking about in Reader? Certainly not. Fourth and finally, and I think this sort of gets to Justice Brissett's question, the Supreme Court looked at what it called, I thought this was an interesting phrase, they said, we're going to look at the context of the contracts, which I guess is sort of under that general rubric of we can always look at the circumstances. We look at plain language, but we can look at the circumstances in which it was enacted. And here, there is no question. The parties, and by the way, not principally us, principally Saturn, treated these as the same contract. And here are just, I don't want to take too much of my time, but let me just give you a few examples of that. Saturn invoiced Evolution at the very end of this relationship for charges all the way back from 2016 when it was an MFA contract. They were invoicing Evolution for those charges without any suggestion that these were different contracts, right? And by the way, they are here today asking you to award them those same damages from December 2016 against Evolution and BMH from what they contend is a completely unrelated contract under Reader. They carried over all the balances from MFA to Evolution. Saturn's own witness testified that the only change at any point was, nothing changed. We just sent the invoices to a different person. We sent them to Evolution instead of MFA. And what I thought was the best description, and this was Saturn's witness, it's in our brief, at one point referred to the contract with the airplane. And I know that's not technically right, but I was like, that's perfect. That's exactly how everybody viewed it. You know, Saturn was operating this airplane, BMH owned this airplane, and all of this was just part of one transaction. Now, I am not suggesting that Reader means that Judge Abels had to view it that way, but based on a whole bunch of evidence, just a little bit of which I have shared with you just now, that was a permissible view and entirely consistent with the principles the Supreme Court looked to in Reader. I think if you look at
But should we look at all, when you say bring up the context language of Reader, We certainly don't want to get to a point where we look at contracts with totality of the circumstances intent, because that 2020 hindsight of intent is very different than intent at the time of contract, right? And if there's ever a time for certainty in the law within business transactions, it is now. So should we take into account all those things that you just talked about that were the conduct of the parties after the transaction was documented?
I think that is obviously, and the court was very clear in saying you have to be you're treading in cautious waters, right? I forget how they phrased it in Reader, but they said be very cautious but yes, I think this is one of those rare cases. And again, we tread lightly and be cautious, but where you can look to the circumstances and see that this really was one transaction. That these contracts really are. And none of this, by the way, we don't believe any of this does any violence to the terms of the contract. It would be different if that were the case.
And are you saying it's all one transaction so that you can construe all of them together?
Yes, and that's all. We're not asking you to ignore unambiguous language or anything. That would be so improper based on the conduct of the. We're just saying, yes, they can be construed together, consistent.
So where's that one transaction end? I mean, I totally understand if you're entering into a transaction and you have 3 or 4 things you're going to have to document, it might take you a couple of months to get it all done. That's all one transaction. But to do a lease and then a sublease and all that, I can see the sublease and the dry lease and the subordination agreement all being one transaction. But an amendment and an assignment that happens a year later, should that be part of one transaction?
Yes, and thank you. I forgot to say the smartest thing I had to say. Reminded me. The biggest difference between this case and Reader is they made the later contracts effective on the original date. They made could there be any clearer evidence that that was what they were intending, that this was one transaction? Yes, they signed that new or amended sublease, however long, like a year later, whatever it was, and they made it effective the date of the original sublease. And I can't believe I forgot to say those words. But so yes, I certainly, I think your point is well taken, Your Honor, but I think this is one of those cases where all of the circumstances, all of the context, all of the conduct, and it doesn't cause you to have to ignore any contractual language to get there. So we believe they should be construed as one overarching contract that simply at one point was assigned from the predecessor entity to the successor entity. A couple other things I will just mention in passing here, and then I have something else kind of totally different. I want to address your question 3 in some detail, actually. Question 1, though, you did ask question 1, so I want to make sure I answer it. Which agreement controls? And that's a simple one. Assuming the subordination, if the court concludes the subordination agreement was effective, it's got to be the subordination agreement because Saturn agreed to that. 7.4 of the subordination agreement signed by BMH and Saturn says, in the event of any conflict with the sublease, the subordination agreement controls. So again, you'd have to first assume it was effective, but if you conclude it was effective, then it
Do you agree with the appellant that you had other options in terms of suing for the same damages under other contracts?
Honestly, I'm not sure. Probably. This was the option we chose, and I think it was a permissible option. We think that's pretty plain, actually. Something else I also wanted to mention about the effectiveness. I know counsel didn't argue some of the arguments about the subordination agreement, but something that does, only because it wasn't mentioned in the briefing. That issue was not decided at trial. I think if you read the briefs, you might be left with the impression that it was, and it was not. That was decided on summary judgment. The parties filed cross motions, and that orders at 8991 of the clerk's record. And it's referenced in the judgment, and Judge Abels also referenced it in conclusion of Law 10. He said, I'm incorporating my summary judgment that the subordination agreement was effective. I only mention that, and again, counsel didn't argue it, but I do mention it because it forecloses their consideration argument because they never raised it in the summary judgment reading.
So if it was a summary judgment ruling versus a finding de facto, are you intending we do a de novo review on that?
I think you would be reviewing that, yes, but I don't think it matters. And the reason it only matters to me to the consideration issue because everything else is contract interpretation anyway. I think, or maybe not the intent of the parties. That would be factual, but in terms of the effectiveness. Now we're only arguing about the effectiveness. We're talking about the effectiveness of the subordination agreement here. That he decided on
Whether it was terminated or not.
Correct, and I think that's all legal conclusions. So in our view, doesn't make a lot of difference other than it does.
But did Judge Abels find as a matter of fact that it had not terminated, or was it only in the summary judgment ruling?
I will have to look at the findings of fact to remember. No, he made
did.
findings of fact that it was not terminated. He absolutely did.
Yeah, he
He did.
definitely
He
mentioned.
definitely did. Yes, he absolutely did. Okay, so we wanted to talk a little bit about what your third question, evolution's damages. And the reason really is because not so much that issue, which isn't candidly such a huge part of the appeal, but because it kind of catches Saturn's counterclaim. And that is important to us to make sure the court understands why that counterclaim properly was rejected. And it's the same reasons that Evolution's award is proper. Okay, so just to remind the panel, Evolution recovered the $60,000 security deposit that was paid at the front end, and then about $19,000 in stray damages. Okay, I know I'm confident I know where Judge Abels got the $19,000. It was, I've written it down here. I think it was Exhibit P188. And I think he felt after hearing 2 weeks of testimony that he could derive the amount he derived from that exhibit. In candor, we're not so sure the Court of Appeals could meaningfully review that based on the record as it exists. And so we are going to concede that 18,000 and change should be remitted. Okay, we're only defending the 60. But the 60 was entirely proper. And let me explain why. And it's the same reason that the counterclaim was properly rejected. What they're trying to do here, they have this argument somehow that the outstanding balance is undisputed. So I think the starting point is to talk about how they proved up this amount they're allegedly owed. They did it all on records, right? They just dumped the records in, and then they had a witness show up and testify from the records. But she didn't even work at Saturn when any of this happened. She came in after the fact. All she did was review these records. In fact, their exhibit book that they gave to you, you can see it in her testimony. She's asked specifically about that $60,000 security deposit. Was it applied? Yes. How do you know? Oh, I can see it in my books. So she admits she has no personal knowledge of anything. She's just looking at records. Now, here's the rub. It is impossible for me in 5 minutes and 28 seconds to share with you the unbelievable load of evidence Judge Abels received that these records were falsified. I mean, it was just start to finish falsified records. I'll give you just a few examples. There was the predicate testimony that there was an entire corporate culture at Saturn, top to bottom, of corruption. Not just with us, but with all their customers' financial billings being falsified. There was testimony of them instructing mechanics to falsify entries, duplicate entries, inflate charges, charge for work they didn't perform. And that's not even getting into the uncertified mechanics and the stoned and, people on whatever that did these services. I mean, just tremendous evidence. The hangar charges. This is one of my favorites because they kind of jump up and down in the brief about these hangar charges being undisputed. Well, Nelms, the whistleblower, said we never put it in the hangar. We didn't have enough room. We had more planes than we had hangar space, so we just parked theirs outside and left it there. That's at 4 Reporters Record 113. Jamie Thomas, the pilot, he even testified that they were falsifying flight logs. These are the logs of when this thing is in the air, flight logs, and telling pilots not to make what are called discrepancy entries. I can't, convey how serious that evidence is in terms of aircraft safety. And then Ms. Clark herself admits that she was the third accounting person to do a full top to bottom audit of our account. And they all came up with different numbers. And one of them was dramatically different than the others. That's 7 Reporters Record 49. And it just went on and on and on. And here's the critical point. They never even tried to rehabilitate the records. I mean, they didn't bring in a witness to say, well, wait a minute, I was there. I saw this particular service or that one, or I know this was a legitimate third party, page X and so is from a third party vendor and that was legit and we paid nothing. Ms. Clark just showed up and testified from the records. And the trial court, if you look in the findings of fact, you'll see when he's talking about this issue, he repeatedly uses the words lack of credible evidence. So I think the trial judge looked at this and said simply, I can't attach any weight to these records or to the testimony of a witness who said she's relying on these records. And he denied it. And he concluded they had failed to establish application of the $60,000 deposit. And so we just wanted to make very clear to the court that the $60,000, that's important to us, obviously, but also the fact that the counterclaim was properly rejected. Now, in response to this, I will say they cite 2 pieces of testimony, and I would characterize them as snippets. One is from Heath, The allegation from Saturn is that Heath admitted he couldn't dispute any of these amounts. Not exactly what he said. What he said was, I can't offer any opinion about any of the accounting because they never gave me any invoices. He said, I can't tell you we owe, we don't owe, what we owe, what they owe, nothing. So they wouldn't give me any invoices, so I don't really have any knowledge of it. They also point to testimony from Jamie Thomas, one answer that they claim in which he essentially verifies these amounts, and it's at 6 Reporters Record 100. I won't spend a lot of time on it. I'll just say I'm confident if the panel will review that in context, reading the 2 pages that lead up to it. Yes, there is a way you could look at that answer super hyper literally and say, well, maybe he was actually saying that if Saturn had never breached a contract, this was the amount owed. I think Judge Abels in context was perfectly entitled to say all he was really saying was if Saturn had never done anything wrong, if they'd abided by all the contracts, they were entitled to be paid. He wasn't verifying some particular lien amount. He was just sort of confirming that principle. The bottom line is this trial really start to finish was about 2 things. It was about a massive amount of evidence of wrongdoing by Saturn in terms of permitting employees with substance abuse problems to service an airplane, in terms of falsifying maintenance that was not done, all of that, and threatening. There was ample evidence, testimony that this did deem the aircraft dangerous to people flying on it. And secondly, the massive amount of evidence of falsified charges by Saturn.
Let me ask you a question. You got 1 more minute, and I want to make sure we
Yes.
address the award of damages against Saturn. Because you were just talking about Saturn's right to recover. So I'm a little concerned about the fact that the findings by the trial court award those damages in the context of the provisions of the contract, which basically, if you look at the subordination agreement and you argue that it's still in effect, it says that the lessor should be liable to.
Yes. Really important point. Yes. Okay. So if you remember the sequence of events here, in the sublease, you have the provision in 9.2b that
Right.
says Saturn liable to Evolution, right? Okay, fine. And then you get the subordination agreement that says we can enforce that directly. So now Saturn's liable to us for any breach. And then we get the additional sentence saying, oh, and Evolution, we can go after Evolution for damages. So those aren't inconsistent. It's just a second pocket for us to reach into. When you construe those together, which is of course what we're trying to do here, those don't conflict in any way. We have one provision that says we can go after Saturn, and we have one provision that says we can go after Evolution, 2 pockets instead of 1. That's it. So they're not inconsistent. They're entirely in harmony with one another.
Thank you very much.
My time's up, so thank you.
Perfect timing. Thank you. Ms. Baker, you have 10 minutes.
Thank you. Okay, first of all, I'd like to address all the comments about Saturn's alleged misconduct, which the trial court found, but that's not at issue here. These are legal questions about who's entitled to what under what contracts. And, my friend on the other side talked about findings of fraudulent invoices and all that. There was no such thing. They did not prevail on any of their findings of fact about fraud or concealed documents or anything like that. So I just want to put that to the side real quick. Even if the court disagrees with Saturn that the assignment of dry lease did not terminate the original sublease and subordination agreement, I still did not hear how it's possible for the subordination agreement to be read or the original sublease in conjunction with this new sublease that clearly governed the parties' relationship with regard to the lease of the aircraft. And it wasn't just that there were new parties, and it wasn't just that MFA is not mentioned and BMH is not mentioned. There were new terms in this agreement. There was an increase in the lease rate for Saturn of up to 20%. There were new charges that the lessor had to cover, internet charges, catering charges. This wasn't just a simple switch or overlay of one contract over the other.
What would be the purpose to retroactively date it to the original?
I think just to cover, the other side brought up, well, you can't, it's evidence the original sublease must have continued because they were charging for things back in 2016. And I think the intent was parties can intend to backdate an agreement. It was to cover the entire relationship. And so the fact that we may have treated some charges and that kind of thing as something back in 2016, Evolution and Saturn agreed that they could backdate that and have that cover the entire relationship.
What about his argument that construing this to terminate the subordination agreement by the actions of two parties without BMH being involved goes directly against the intent of what this whole transaction was meant to protect?
Well,
And it's specifically talking about that last new lease, BMH is not a part of.
correct. BMH is not a part of. It is still a party to the dry lease, which with Evolution, which was substituted for MFA. And in that dry lease, it can sue Evolution for any breach of the dry lease by Evolution or any default of Saturn under the new sublease. So BMH isn't left like out in the cold without a remedy. If they wanted the subordination agreement to apply, they should have done what they did the first time, which was, hey, we need parties to agree to this. And BMH
If they had any notice that the new lease went into effect.
Well,
That's what I'm struggling with. You're talking about BMH losing some material rights that evidently everybody thought that they should have because two other parties without their knowledge, maybe, entered into another contract, which you says has the effect of terminating BMH's rights.
well, BMH agreed in the subordination agreement that subordination agreement would terminate with the original sublease.
Mhm.
And so BMH wasn't a party to the original sublease either, yet they agreed in the subordination agreement that it would terminate if the original sublease between two different parties, not BMH, terminated. So they essentially signed a statement saying that two other parties could decide to terminate the subordination agreement with or without their participation. One thing I wasn't sure what my friend was saying on the other side about consideration. That was a matter discussed at trial, and their big point on consideration is that, well, we could have taken away the lease, but that was, they weren't the ones that had directly leased the airplane. And in addition, the sublease provides that it cannot constitute consideration for any other agreement. So that's just real quick on consideration. On your last question, Justice Brissett, about damages awarded to Saturn. The other side says that 9.2B and 7.1 and 7.4 can all be mushed together. But under Occidental, it really cannot. You cannot breed a provision out of a contract. And 7.1 of the subordination agreement, if it's applicable and operable, which we don't concede, says lessee, which at the time of the subordination agreement was MFA, if you say it carries forward in its evolution, shall be liable for any costs, charges, or expenses incurred by lessor, BMH, in enforcing or protecting its rights under this agreement. All of the damages awarded were described as costs. Heath, BMH's owner, conceded at trial that all the categories of damages, including fees, were cost, charges, and expenses incurred by BMH in enforcing its rights under the
So
subordination
is
agreement.
this an alternative argument? Because if you argue successfully here, you're arguing that the subordination agreement isn't in
Yeah,
effect.
that's what this is.
Okay.
This is a separate argument. I'm saying even if you believe and you all find that the subordination agreement is in place, it applies to this new sublease, and it was part of the mix of these parties' agreements. So yes, alternate argument. If you believe that, then you have to give effect to 7.1. And as they say, 7.4 says that in the event of conflict between the two, between the subordination agreement and the lease or the sublease, this agreement shall control. So our position is, even if the subordination agreement were to apply, even if it's operable somehow to the new sublease, under Occidental and a lot of other case law, you cannot ignore the plain language of 7.1, which makes MFA / Evolution liable for the damages that were awarded here.
I have a question. Doesn't it also say in 7.1, the lessor may exercise any and all of the rights and remedies under the lease, free and clear of all the interests of the lessee? That doesn't apply.
Well, I think especially because that language is in the same section, that is also in 7.1,
Mhm.
and that's the same section that ends with lessee shall be liable for all costs, charges, and expenses incurred by lessor.
Well, costs and expenses, is that, you're saying that's the same as all damages, or is it just for the cost of fixing a plane or the expense of that? I mean, remedies and damages and costs and expenses seem different.
Yes, and I understand your question, and it is a good one. I think here, a couple of things on that. Here, the subordination agreement says at the front that under the recitals, the last recital, whereas lessor, sublessor, and sublessee desire to further define and to establish and acknowledge lessor and lender's rights relating to the aircraft. So that's encompassing everything within the agreement. So the way that we read the subordination agreement, and I think the correct way to read it is that any cost, charges, and expenses incurred to enforce those rights found within this document, the subordination agreement and BMH specifically agreed that lessee shall be liable for those cost, charges, and expenses. It doesn't mean that if the subordination agreement remained in effect and was operable to the new sublease, that doesn't mean that BMH didn't get anything from Saturn. Saturn still subordinated its interest in the aircraft, agreed to things about insurance and other things. And so it's not that renders the whole contract unimportant or illusory on the part of Saturn. I mean, we say Saturn didn't get anything out of the agreement, but BMH clearly did. And it clearly provided that these cost, charges, and expenses, which were described as costs.
Real quick, is that what the
Yep.
trial court hinged the damages on? Is that one sentence when they awarded damages?
I don't know. They did describe all the damages as costs. And BMH's owner, Heath, again agreed that all of the damage, the categories of damages, including fees related to litigation, were cost, charges, and expenses. I see that I'm out of time. Unless you have further questions, I'll be done.
Thank you very much for oral arguments this afternoon. Your case is submitted. You will be notified as soon as we have an opinion. Thank you very much. We are adjourned.
All rise.